Ma'am, stop right there. Don't move.
I'm sorry, this is my home. Who are you?
Immigration and Customs Enforcement. We need to ask you a few questions.
About what? You're in my driveway.
Step away from the vehicle. Put the books down.
Am I being detained?
Your behavior doesn't add up. We received a report about someone matching your description.
What description?
I live here.
Two ICE agents thought they were running a routine immigration enforcement stop. They had an address, a tip from an anonymous source, and the kind of confidence that builds up in men who have spent years operating without consequences. But when they pulled into the driveway of Jasmine Ellison at 11:02 a.m. on a Tuesday morning and attempted to detain her without a warrant, without probable cause, and without a single piece of legal documentation authorizing their presence on her property, they set in motion a chain of events that would end with both of their careers obliterated, their names permanently attached to one of the most documented civil rights violations in recent federal enforcement history, captured in full by a security camera they never once looked at. The camera was already recording when they arrived. It never stopped. Jasmine Ellison was 26 years old. She lived in the house her grandmother had left her, a 2-bedroom in a quiet residential neighborhood, the kind of block where people wave from their driveways and know each other's dogs by name. She was 3 years into law school at a regional university, financing her education on scholarships and federal loans, and a part-time job she had given up the semester before because the coursework load had become unmanageable. She was not wealthy. She was not well connected. She did not have a chief of staff or a congressional seal on her front door. What she had, stacked in her arms when she stepped out of that house on the morning of February 18th, were her casebooks. 3 folders, a constitutional law textbook with a broken spine from overuse, and a worn leather bag over her shoulder. She had a mock oral argument that afternoon. She had a navy blazer on, because she took that kind of thing seriously. She was locking her front door when Agent Mark Caldwell stepped out of a black government SUV and positioned himself between her and her car. She did not know his name yet. He did not introduce himself. He looked at his clipboard first, then at her, and said, "Ma'am, we're going to need a few minutes of your time." What happened in the next 47 minutes? Every word, every demand, every silent pause was recorded in 4K from a camera mounted at the corner of her porch, syncing automatically to cloud storage every 30 seconds. Entirely outside the control of the 2 agents who were about to make the worst professional decision of their lives. Agent Mark Caldwell had been with ICE for 11 years. In that time, he had accumulated a personnel file that his supervisors described in internal review language as a pattern of escalatory field conduct. 3 formal complaints in 5 years. 2 use-of-force reviews that were closed without finding. A commendation mixed in with the complaints, which is how these things tend to stay buried. He was not a rogue agent in the way movies depict rogue agents. He was something more ordinary and more dangerous. A man the system had repeatedly decided was fine. His partner that morning was newer, 2 years in, still learning what the job expected of him, which is to say, still learning what it permitted. They had received an anonymous tip. The tip alleged, in vague terms, suspicious activity at a residential address. The address was Jasmine's. There was no name attached, no specific allegation, no corroborating information of any kind. There was no warrant. There was no probable cause affidavit. There was no supervisor authorization for a residential stop. There was a tip, a clip, and a government vehicle, and apparently that had always been enough before. At 11:02 a.m., the camera recorded both agents climbing out of the SUV. Caldwell walked toward Jasmine with his badge out, held at a distance, visible but not readable. His partner moved to her left, not aggressively but deliberately. The formation was efficient. It was also a wall. "Ma'am, stop there. We need to ask the friends. Stop there." Jasmine stopped. She looked at the badge, then at the vest, then at the second agent now standing 6 feet to her left. She said, "Who are you, and do you have a warrant?" "Immigration and Customs Enforcement," Caldwell said. "We've received information about this address. We need to verify a few things. We're not here to cause problems." "Then show me the warrant." "We don't need a warrant for a compliance check under federal immigration authority." Jasmine's grip tightened on her casebooks. She knew with the precision of someone who had spent 3 years studying exactly this, that what he had just said was not a legal standard. It was a phrase, a confident-sounding phrase dressed in procedural clothing. She had read the cases. She had written the briefs. She knew the Fourth Amendment's application to residential property better than most practicing attorneys. And she knew that the man in front of her was either misinformed or counting on her not to be. "I am not volunteering for anything," she said. "I'm asking you to show me the legal basis for your presence on my property." "Non-cooperation can be noted in the report, man." "What report?" He did not answer. He asked for her identification instead. The next 20 minutes, preserved in full on the security footage, are a masterclass in what bureaucratic danger actually looks like. It does not look like shouting. It does not look like drawn weapons. It looks like a woman standing in her own driveway, holding her own books, repeatedly showing her identification to a man who keeps finding new reasons why it isn't sufficient. Caldwell asked her to hold the ID still, then to tilt it. Then he radioed in the name. Then he said there was a delay in the system. Then he asked her again not to go inside. Then he told her that moving toward her front door could be interpreted as flight risk behavior. She did not move toward her front door. She stood exactly where she was. She asked a total of 7 times across those 20 minutes for a warrant. 7 times. The camera's timestamp kept moving. A neighbor across the street came outside, paused at their car, watched for a moment, and left. At 11:24, Caldwell put his radio away and stepped toward her. "Man, I need you to put the books down and turn around." "On what legal basis? You're being detained for questioning under—" "I know what you're about to say," Jasmine said. "And I want you to hear me clearly. I am a third-year law student. You do not have a warrant. You do not have probable cause. You are on private residential property. If you touch me, you are committing a federal crime. And that camera? You did not point, did not need to, has been recording since before you got out of your vehicle." Caldwell looked at the camera. 11 years in, and he looked at it the way someone looks at something they should have noticed 6 minutes ago. He touched her arm anyway. The footage shows it clearly. Caldwell grips her right arm. She pulls back, not violently, not aggressively, but with the firm, deliberate motion of a person invoking a right. His partner moves in from the left. The casebooks fall. The folders scatter across the driveway in the midday sun, paper sliding across concrete, her constitutional law textbook landing face down at the edge of the lawn. She does not yell. That is the thing that stops people when they watch the footage later. She does not yell. She says, in a voice that is controlled and clear enough that the camera's audio picks it up without distortion, "You do not have authority to touch me. I am not resisting. I am invoking my Fourth Amendment rights. This is being recorded." They handcuff her anyway. The camera records the click. It records her face. It records the second agent picking up his radio. It records the timestamp, 11:26:14 a.m. A neighbor 2 houses down, a retired teacher named Gloria Merritt, had come outside when she heard voices. She had her phone out. She started recording from her porch without fully understanding what she was seeing, because what she was seeing was a young woman in a blazer being handcuffed in her own driveway on a Tuesday morning, surrounded by federal agents and scattered law books. And that was not something Gloria Merritt was going to watch without documentation. 2 other neighbors appeared within minutes, all of them recorded. None of them were close enough to intervene in a way that felt safe, and they knew it, and Caldwell knew they were there, and he moved Jasmine toward the SUV anyway, her shoulder at a wrong angle, her feet finding the ground carefully, her voice still steady. The footage was uploaded to cloud storage at 11:32, 11:33, and 11:34, 3 separate sync intervals, 3 redundant copies, none of them accessible to the agents who had just driven away. By 11:55, a legal accountability page had the driveway camera clip. By 1 p.m., it had 40,000 views. By 3:30, it had crossed 250,000, and every major outlet had sent a request for the full file. At the field office, Caldwell brought Jasmine into a holding room, and attempted to begin questioning. She invoked her Fifth and Sixth Amendment rights within the first 30 seconds and did not speak again without an attorney present. She sat with her hands in her lap and waited, because she knew, had always known, since the moment Caldwell's hand closed on her arm, that her job now was simply to outlast the next phone call. The phone call came at 12:01 p.m., a supervisor. Then another call. Then, 11 minutes later, a field director who had been watching Twitter on his lunch break and now understood, with the specific clarity of a man whose career is flashing before his eyes, exactly what had been recorded on that driveway. Jasmine was released at 12:14 p.m. No apology, no explanation beyond a supervisor who told her there had been a miscommunication regarding the address, and thanked her for her cooperation, a word choice that the footage would later make deeply ironic. She was handed her phone. Her casebooks were in a plastic evidence bag. The bag had been labeled with a case number that would ultimately be closed without charges, without referral, without any official acknowledgement that she had been arrested. She signed nothing. She said nothing. She walked outside into the early afternoon, called her mother, and told her she was fine. She was 2 hours late to her mock oral argument. She did not explain why. She argued her case. Her professor told her afterward it was one of the sharper performances he'd seen from her. The footage didn't need commentary. It didn't need a caption. It was 47 minutes of a young woman in a navy blazer, standing in her driveway, asking for a warrant, while 2 federal agents told her, in escalating procedural language, that she didn't deserve one. And it was all time-stamped. All cloud-backed, all irrefutable. The Office of Professional Responsibility opened a review within 72 hours. The review found what the footage had already shown anyone willing to watch. No warrant had been obtained or sought. The anonymous tip contained no specific actionable information that would meet the threshold for residential detention. The agents had been trained on Fourth Amendment residential property standards. They had been trained on the precise situations the law required warrants. They proceeded without one. 6 weeks after the incident, both agents received termination notices. The stated reason was conduct inconsistent with agency standards and federal law. The termination letters were 2 paragraphs. The press release was 4 sentences, passive voice, no names. What the press release did not say, Cowdell had filed for wrongful termination review. That process was ongoing. His union had assigned representation. The termination was, at the time of this writing, not yet final. What it also did not say, no criminal charges had been filed. Termination is an employment action. It is not a legal one. Jasmine Ellison was detained without a warrant in her own home, and the men who did it lost their jobs. That is a consequence. It is not the same thing as accountability, and the difference matters. The trial came, not a criminal proceeding, but a civil one, and it moved the way civil cases move. Slowly, with a great deal of paper, and without the dramatic arc of a jury returning a verdict in a single day. Jasmine, represented by a civil rights attorney she found after 2 weeks of calls that went unreturned, filed suit against Caldwell, his partner, and the agency. The deposition footage is not public, but the documents are, and they show what the driveway camera had already suggested, that Caldwell, when asked to identify the legal standard he believed authorized a warrantless residential detention based on an anonymous tip, could not cite a statute. He cited operational authority. He was asked to define that. He could not. His personnel record, entered into evidence, showed the stories that stand for several months are stories of millions of deaths around him. It showed the commendation that had kept the file from triggering automatic review. It showed 11 years of a system making a series of small decisions that added up, eventually, to a Tuesday morning in February. The civil case settled. The terms are confidential. A statement from Jasmine's attorney said only that she was satisfied with the resolution and committed to continuing her legal education. No number was disclosed. No admission of wrongdoing appeared in any public document. That phrase, no admission of wrongdoing, appears in a remarkable number of settlements involving federal agents. What changed after February 18th is worth accounting for carefully. because the accounting matters. Agent Caldwell and his partner no longer work in federal law enforcement. That is real. The footage is archived in multiple locations and has been cited in at least 2 law review articles and 1 federal oversight hearing as an example of residential Fourth Amendment violations. That is real. The civil case produced a settlement that, whatever its terms, was a cost the agency absorbed. That is real. Jasmine Ellison upgraded her cloud storage plan the night of the incident. She checked her camera's sync settings 3 times before she went to sleep. She was 2 years from taking the bar exam. Before February 18th, she had been considering immigration law. She has not revisited that in any way she can describe as settled. She walks a slightly different route from her car to her front door now. Not dramatically different, not dramatically anything, just different. She was assigned her own driveway footage as supplementary material in constitutional law the following semester. Her professor presented it without attribution. She sat in the room and watched it play on the projector and did not raise her hand. And when the class discussed the Fourth Amendment implications, she answered 2 questions correctly and said nothing else. She has thought about getting a therapist. She has not yet. The agency that employed Caldwell and his partner continues to operate. New agents are hired each quarter. Tips are received and acted upon. The protocols that failed to prevent what happened in that driveway have been updated. New language in the training materials. A revised checklist for residential stops. Whether that is meaningful depends on what you think causes a man with 11 years of training to approach a woman's home without a warrant and handcuff her when she asks for one. Should federal agents face mandatory criminal prosecution, not just termination, when warrantless residential arrests are documented on video? The comment section's open, because what happened in Jasmine Ellison's driveway was not an anomaly. It was the visible edge of something much larger. The neighbors who filmed that morning, Gloria Merritt and 2 others who have not spoken publicly, were not celebrated as heroes in any formal sense. Gloria mentioned it once at a neighborhood meeting. She said she had not known what she was seeing at the time. She had just known it looked wrong. She had just known she should document it. That instinct, simple, civilian, untrained, is what made the difference between a 47-minute detention that left no official record and a 47-minute detention that is now in a law review. The driveway is still there. The camera is still mounted at the corner of the porch. The timestamp in the footage still reads 11 years of institutional permission and no warrant, toward a young woman holding her casebooks on her way to school. They did not know what she was carrying. They did not know what the camera was doing. They did not know, in the confident, procedural efficiency of men who had never been wrong in a way that counted, that they had just made the last professional decision of their careers. Jasmine Ellison will graduate. She will pass the bar. The kind of law she decides to practice is still an open question. And that openness, the fact that a decision she was moving toward before February 18th now sits suspended in something she hasn't fully named, is perhaps the most honest accounting of what that morning cost. Not the footage, not the terminations, not the settlement. The version of herself she was walking toward, casebooks in hand, before a federal vehicle turned into her driveway and stopped her. That cost doesn't appear in the press release. It doesn't appear in the termination letters. It doesn't appear anywhere in the official record of what happened on February 18th, because the official record is not interested in what it cannot quantify. But it's there, in the way she routes around her own front door. In the storage plan she upgraded at 11 p.m. because she needed to feel like something was secured. In the mock oral argument she walked into 2 hours late, saying nothing and somehow still delivered clearly. The cameras caught what happened in the driveway. What the cameras couldn't catch was what she carried back inside when it was over. If you believe documentation is the first line of accountability, and that the people most often targeted by illegal enforcement are the least likely to have access to it, this story needs to reach them. Subscribe and share it with someone who needs to know their rights before they ever need to use them.